Dear participants, we can start the program. Sir, very good morning, sir, and very good morning to all of participants joined today. Today lecture will be taken by the Professor Dr. Manoj Kumar Sinha, Director Indian Law Institute, New Delhi, and former Director Indian Society of International Law.
Thank you, Barmaji. So we can start, I think, right now. But
Sir, sir,
uh, we have so like how many like minutes I have?
sir, 11:30, 11 or 11:45.
11:30 is fine. I think
11:45, sir.
11 is
Sir,
1.5 hours.
3 takes, sir.
So all right, thank you very much, Dr. Yogendra Kumar Barmaji और सभी सहयोगी और पार्टिसिपेंट। आज का जो चर्चा का विषय है जो मैंने लिया है उसको मैं हिंदी में भी और इंग्लिश में भी बोलने की कोशिश करूंगा और बेसिकली इस implementation of international human rights law at the domestic level like कैसे अंतर्राष्ट्रीय संधि और मानवाधिकार की संधि और in general we can put how implementation and enforcement of international law in general and international law in general and specifically focus is the international human rights law, how international human rights law or international public international law are applied in the domestic perspective, and that is very important we have. So when we look into this particular implementation aspect uh, related to the implementation of international treaty at the domestic level, we have to look into the constitution, what kind of system we have. So application of international law depends on the uh, system we follow, like monism or dualism. So as you are aware that we have dualism system, we believe in the uh, to apply international treaty we have to do extra step. It will not automatically, international law will not be applied at the domestic level, so it will not. So it sees that international law and domestic law, so we believe along with many states there are two different set of the laws, international law and domestic law. So domestic law will be applied automatically when parliament passes a legislation, it's become law of the land, it's applicable to all of us. However, international treaty, even if we accept the agreement, even if you go to the we accept the international legal obligations, its status will not change. It will not become a treaty applicable to domestic level. So what we have to do in the constitution, if you look into the Indian constitution, the constitution has laid down clear cut procedure. What it says, like the international treaty will become law of the land once like a treaty is passed by the parliament under the article 253 of the Indian constitution. So enabling legislation, passing of the enabling legislation, when we pass the enabling legislation, treaty becomes the law of the land and it will be automatically applied. So that is required. This is the procedure which we have, executive has to follow. They sign, they ratify a treaty, and after ratification of the treaty has to be placed before the Indian parliament and parliament has to approve. If parliament approves, then the treaty becomes law of the land. and automatically it's become applicable to it's acquired the status of law of the land. So since we have a dualism, we believe that a special procedure is required, a special steps is required to making international treaty a domestic treaty. In some country which believes in the monism, they say कि international law and municipal law are same, integrated. They don't see separate international law and municipal law, and they say that it automatically applies in those country. In monist country, they automatically international law treaty. So effectiveness of international human rights in the monism, like the states which follow or believes in the monism, much better compared to the dualist state or believing in the dualism. That's like, it's very difficult. Uh, as I said in the beginning, the implementation and enforcement of international law in general, in public international law and international human rights law is problematic. It's not very simple. It's a problematic. When we talk about why it's a problematic, so when we look into the international law in general, what we see, all states are equal. Sovereign equality, the principle of sovereign equality, irrespective of the fact of the size, population, military strength, all states are equal. The principle of sovereign equality applies, and no state wants the another state should interfere. So when we talk about the international law, public international law, and international human rights law, we say states are reluctant. States are very reluctant to allow external agency or external bodies to interfere in the domestic affairs of a state. So they are very conservative. When it comes to they are very conservative. States are very conservative when it comes to the respect of the international law in general and international human rights law. Though they are a mechanism, there are enforcement bodies available under the international treaty. There are like no enforcing bodies is there, but still implementation remains a daunting task. Implementation remains a challenging task for the international body as well as the state. It's remain a big challenge for the implementation of the international human rights law. To make international treaty, we have to pass enabling legislation in uh, under Article 253 of the Indian Constitution. Then a treaty acquires the status of law of the land. This is the one aspect. We'll also try to examine a little bit later how the ultimately interpretation and application of the treaty depends huge way on the interpretation by the judicial system of a specific country. How a judiciary interprets, how a judiciary apply a treaty at the domestic law, that becomes very important and very fundamental. So when we discuss all these things, so there are two procedures. One is executive measures and second is the judicial interpretation. So implementation of the treaty at the domestic level, we have to examine in two folds. The first, executive, by the implementation of the treaty by the executive or state authorities, and second, how the judiciary uses international law at the domestic level. So twofold we try to understand the executive measures. In the executive measures we have, we'll see that how executive, how government of India is implementing or respecting the treaty on its own, and how and the second aspect, which becomes judicial interpretation, judicial application of for the international treaty. Uh, while trying to understand judicial interpretation and application, they look independent of executive measures, or they see that executive measures have to be complied and then judiciary will implement. That is the interesting fact which we have in a soon we'll try to examine and understand on that particular thing. Take an example. Today we'll discuss one or two important cases related with the uh, implementation of international human rights law at the domestic level, and how court has interpreted, how court has said, and how as a teacher of law, we have to also, when we go in the class, we talk about the implementation aspect, we can utilize, we can take note of the judgments of the Supreme Court and judgments of the High Court of India. Take an example of the first human rights treaty, which we like will start. What obligation we have when we talk about the implementation? We have to look into the obligation. So we start with the very first treaty, that is the International Covenant on Civil and Political Rights. So in today's context, we try to understand how international covenant and civil and political rights are applied in India. What are the steps government of India has taken in the application of the application of the International Covenant on Civil and Political Rights at the domestic level. So first we start with the International Covenant and Civil and Political Rights. As you are aware that International Covenant on Civil and Political Rights and International Covenant on Economic, Social and Cultural Rights are two important international human rights instruments in general. So they are general human rights instruments. They encompasses everything. They compasses civil and political rights. They talks about the right to child. They talk about the right to minorities. They talk about the women. So it's a general human rights instrument, and you have a specific human rights instrument. A specific human rights instrument like Convention on the Rights of the Child. It talks about the only on the child. You have a convention on the elimination of all forms of discrimination against women. It talks about the only women. So what we have in on the at the top international level, we have two types of human rights instrument. One are general, very general, which talks about everything. Talks about the women, talks about the children, talks about the minorities, talks about the prohibition against torture, talks about the people's participation, freedom of speech and expression. Everything you take into that human rights instrument, that general human rights instrument, are talking about what we have in the constitution, particularly part 3 of the constitution. So two instruments which will be subject of discussion in today's course will be the an international covenant of economic, social, and cultural rights. So when we talk about the international covenant and civil and political rights and international covenant and economic, social, and cultural rights, first we have to identify. First, you have to find out whether we have any commitment under the treaty or not. And this can be verified by looking into whether India has accepted legal obligation under this two treaty. So, taking legal obligation becomes very fundamental. Legal obligations there. So, what we see that government of India has accepted legal obligation uh, related to international covenant and civil and political rights and international covenant on economic, social, and cultural rights. So we have accepted legal obligation on 10th April 1979. On 10th April 1979, we accepted the legal obligation related to the International Covenant on Civil and Political Rights and International Covenant on Economic, Social, and Cultural Rights. So first answer we have got that India is party. India has made a commitment to implement. Government of India has made commitment to implement the international treaty, particularly International Covenant on Civil and Political Rights and International Covenant on Economic, Social, and Cultural Rights at the domestic level. So that aspect is clear. And this commitment was made by the Government of India on 10th April 1979. On 10th April 1979, officially we said that we are bound by, we are going to respect, we are going to ensure the respect of the treaty which international civil and political rights and economic, social, and cultural rights. So we made a commitment to the international body that we are going to apply. So that question has been answered. So when you accept the legal obligation, sometimes State finds is very difficult. State finds very difficult to apply certain provisions, like certain articles. So you are willing to become a part of the treaty. You are interested to become a part of the treaty, but you find certain provisions are very difficult to implement. Interestingly, interestingly, international treaty allows a state to make reservation. A state to make a reservation under the treaty. So what reservation means? You are going to implement the treaty, but certain provisions you are not going to implement. Certain provisions you are not going to implement. So you state can make a reservation. For an example, when we decided to become legal, accept the legal obligation under the International Covenant on Civil and Political Rights and International Covenant on Economic, Social and Cultural Rights, the first challenge government had how to implement Article 1 of the International Covenant on Civil and Political Rights and International Covenant on Economic, Social and Cultural Rights. So first issue before the government, because they found the Article 1 is difficult one. Article 1 is a difficult one of the covenant. So what is Article 1 of the covenant? Article 1 of the covenant, what is Article cover? So how
Right to
are that
determine.
India is bound by the Article 1 of the covenant or not? So Article 1, if you see, it says all peoples have the right of self-determination. So it says all peoples have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. So Article 1 of the International Covenant on Civil and Political Rights and Article 1 of the Economic, Social, and Cultural Rights, it talks about the right of self-determination. It says peoples have a right of self-determination. So people have, it's not individual, it's a collective. It says peoples have a right to self-determination. They can decide for what? To pursue, like, to people have a right of self-determination to determine their political status, and freely pursue. So there is a possibility. So determine their political status means political status, whether you want to remain a part of that particular country or you want to become an independent country. So people have a right of self-determination. So you can understand first aspect itself is very difficult. Right of self-determination, and people have a right to determine their political status. Second is not difficult. Freely pursue their economic, social, and cultural goals. Freely pursue their economic, social, and cultural goals. So freely pursue. So people have a freely pursue, like creation of Jharkhand from the state of Bihar was only on the ground of people wanted we have some kind of a difference that like South Bihar and North Bihar they have there. So constitution also permits what we have. So what we are permitting? We are permitting internal self-determination. And determination constitution also permits some kind of economic autonomy for the cultural identity, for the religious identity, people can within the constitutional scheme. So there is a scope for the internal self-determination, which is justified, and we see the number of states, Indian states have gradually increased one by one, and today we have 28 Indian states. So largely creation of the states, people have struggled. It's not automatically central government has created. There was a struggle for each creation of the state, either on the linguistic ground or on the ground of economic social. But the first aspect under the right of self-determination. So what you have to understand when we talk about the right of self-determination, it has twofold, internal self-determination and external self-determination. So right of self-determination, we have to understand in a manner that it implies twofold. The first is internal self-determination and second external self-determination. External self-determination means you want to secede. You want to go out from the mother country and create an independent country. So accepting of that kind of thing is difficult. So how we have overcome? Because I have just now told, government of India has accepted the legal obligation, gave a commitment that we are going to respect international treaty domestically. As I said in my class few minutes back, the treaty allows a state to make a reservation. So what state has done? They exercise power of reservation. They said, okay, we want to become party of this treaty, perfectly fine, but Article 1 will not be applicable to us. So Article 1 will not be applicable to us. So Government of India at a time, so implementation and non-implementation, you see. So we realized in 1979, we can't have Article 1 applicable to us. Article 1 will be difficult. So that time we said, no, rest of the articles will be applicable, but Article 1 will not be applicable. And that was achieved. That was like, achieved largely because government, government of India has made reservation on the specific item. What government of India has said, what government of India has stated, they said that we recognize right of self-determination. So government of India has said we recognize the right of uh, we recognize the right of self-determination as a human right. So government of India did not deny. They said ki we understand right of self-determination is very important right. So government of India has acknowledged ki right of self-determination is very important right. But when it comes to interpretation, the government of India has said that right of self-determination applies only against the colonial powers. Right of self-determination applies only against the colonial powers. So state which are under the colonial powers, right of self-determination is fine, but not against the newly independent country, So right of self-determination, we accepted, it's a very important right, but we believe that right of self-determination applies only against the colonial powers, like 1940s prior situation, but not on the newly independent country. So when a state decides to become a party of international treaty, so our enforcement is related to the obligation of the state, what obligation a state has under the international treaty. So obligation in almost all international treaty, या अगर आप देखेंगे, आप एग्जामिन करेंगे, if you see all international human rights treaty को जब भी आप खोले कभी भी देखेंगे, so you may find, आपको मिलेगा कि शुरू में ही obligation आउटलाइन किया हुआ है, क्या ऑब्लिगेशन है, क्या राष्ट्र का ऑब्लिगेशन है, जो देश इस संधि का पार्ट हो रहा है उसकी क्या ऑब्लिगेशन है. ऑब्लिगेशन ज्यादा बड़ा और एलोबरेट नहीं होता है, बड़ा सिंपल ऑब्लिगेशन रहते हैं, क्योंकि द फर्स्ट ऑब्लिगेशन जैसे आप खुद कह सकते हैं कि once you have made a commitment, if I have made a commitment that I will come and deliver a talk to you, so I have an obligation that I will come and do that according to your syllabus. Similarly, when a state becomes party to the any international human rights covenant, so एक तरीके से state has undertaken to respect. So state says कि we have made a commitment, undertake to respect. So state has
So
said
pacta sunt servanda. Pacta sunt
undertake.
servanda. So pacta
By,
sunt
by
servanda, the
joining
pledged words
international
must be kept.
treaty, state has made a commitment that we respect and ensure respect. So we respect and ensure respect to all individuals within its territory and subject to its jurisdiction, the rights recognized in the present covenant. तो पहली जो आपकी ऑब्लिगेशन है, यू हैव गिवन ए कमिटमेंट कि वी विल रेस्पेक्ट, बिकॉज ह्यूमन राइट्स की हम जब बात करते हैं, जब इंटरनेशनल कॉन्वेनेंट की हम बात करते हैं या कोई भी ह्यूमन राइट्स की बात करते हैं, तो ये इंडिविजुअल की बात करते हैं। जो राइट्स है इंडिविजुअल को, आपको है, हमें है, ये किसी और के लिए नहीं है, देश के लिए नहीं है। जब हम ह्यूमन राइट्स की बात करते हैं जो संविधान में भी है, तो हमें दिया गया है ये अधिकार, मानव को दिया गया है। वो जो सिटीजन्स है और नॉन सिटीजन्स है उनको भी हमारे संविधान में अधिकार दिए गए। तो अधिकार जो है इंडिविजुअल है। सो इंटरनेशनल ह्यूमन राइट्स भी बात कर रही है वो इंडिविजुअल का, वो नहीं कह रहा कि गवर्नमेंट ऑफ इंडिया जनरल, वो टॉक कर रहा है कि आपको गवर्नमेंट ऑफ इंडिया हैज टू रेस्पेक्ट provision against torture, provision against slavery, personal liberty, due process of law. These are the rights are outlined in the constitution, and these are the rights are outlined in the international instrument. So ये कह रहे कि आप जब हमें कमिटमेंट, सो गवर्नमेंट ऑफ इंडिया हैज सेड कि we respect, we are going to respect whatever the rights under the treaty is there, and recognized for the individuals. So civil and political rights में और economic, social and cultural rights में ये right individual का, आपका है, मेरा है, ये सरकार का नहीं है। तो सरकार की जो दायित्व, क्या दायित्व होती है सरकार की? सरकार की दायित्व है कि हमारे अधिकारों की रक्षा करे। स्टेट हैज एन ऑब्लिगेशन टू प्रोटेक्ट, और हम, उनका दायित्व है कि हमारे राइट को रेस्पेक्ट करे, प्रोटेक्ट करे, रेस्पेक्ट करे और फुलफिल करे। ये तीन बड़ी दायित्व होती है, प्रोटेक्ट, रेस्पेक्ट, फुलफिल। और अगर जब हम बात करते हैं जो तीनों अगर वो फेल कर गए, जब प्रोटेक्ट, रेस्पेक्ट और फुलफिल नहीं करके वायलेट करते हैं, अगर राइट्स को वायलेट हो गया, तो आप जो इंसान के राइट्स को आप वायलेट किए हैं तो रेमेडी होनी चाहिए। और इसी के संदर्भ में हम जब कॉन्स्टिट्यूशन में देखते हैं, हमारा पार्ट 3 में पूरा, तो हमारा कॉन्स्टिट्यूशनल रेमेडीज है। आर्टिकल 32 रेमेडीज प्रोवाइड करती है अगर इन केस ऑफ फेलियर ऑफ द ह्यूमन राइट। सो स्टेट्स लाइक प्राइमरी ड्यूटी टू प्रोटेक्ट, स्टेट्स प्राइमरी ड्यूटी टू रेस्पेक्ट, एंड स्टेट्स ड्यूटी टू फुलफिल ह्यूमन राइट्स। बट आपके वायलेट करता है, आपके राइट्स वायलेट होते हैं, योर राइट्स आर वायलेटेड बाय द एजेंट्स ऑफ द स्टेट। जो सरकार के अधिकारी होते हैं, हरास किया गया है, आपके सर्वेलेंस करते जा रहे हैं, तो स्टेट इज इंस्ट्रूमेंट। सो स्टेट इज प्रोटेक्टर एंड स्टेट इज अब्यूजर आल्सो। तो आपको इस बात की, दोनों बात को, state is protector of the rights and state is abuser of the rights. State also violates your right. That is the main. So state is promoter and state is also abuser. About Afghanistan ki situation, if you take, so in what is happening in the Afghanistan as a state supposed to protect the rights, allow the individuals to enjoy the human rights, but rights are applied discriminately. In the state of Afghanistan, rights are applied discriminately. Women and children have a different set of rights and others have a different set of rights. So a state which is supposed to protect the rights are violating the rights in the state of Afghanistan or in many other states. So state is the problem. So first obligation under the international treaty, state has to respect, been recognized under the वेरियस कन्वेंशन, वो हो सकता है डिस्क्रिमिनेशन कन्वेंशन हो, वुमेन की हो, राइट्स ऑफ द चाइल्ड की हो, जो भी कन्वेंशन है। सो वंस यू एक्सेप्ट द लीगल ऑब्लिगेशन, वंस यू एक्सेप्ट द लीगल ऑब्लिगेशन, यू हैव टू इंश्योर द रेस्पेक्ट ऑफ द इंटायर कन्वेंशन एट योर डोमेस्टिक लेवल। द सेकंड इंपॉर्टेंट इज देयर, कभी कभी वंस यू बिकम अ पार्टी ऑफ द ट्रीटी बट यू डोंट हैव डोमेस्टिक लॉ in line of the international treaty, you don't have a domestic law in line of the international treaty. So what then? You have made a commitment to implement. So state has to adopt appropriate measures. उसमें हो सकता है legislative हो, administrative हो, for the implementation. अगर legislation की जरूरत है तो आप एक कानून लाएंगे और कानून बनेगा उसके आधार पर आप implementation के लिए। So undertake measures to implement. Measures to implement में आपकी आ जाती है जैसे legislative measures, executive measure, administrative measures. That are the measures government will take for the implementation of the treaty at the domestic level there. अगर हम कहते हैं कि IPR में जो हमारा पेटेंट एक्ट है, हमारा कॉपीराइट एक्ट है, हमारी जो ट्रेडमार्क है, significantly. Why? to bring our domestic law in compliance with the international treaty. Our trade law has been significantly changed, largely because of the international commitment, largely because of the international commitment. So trade में it's become so important कि we had to change. Human rights में ऐसी बातें नहीं आती है, लेकिन international trade में it become a big issue, and the obligation to implementation is you adopt a domestic law. You adopt a domestic law in line of the international treaty. In line of the international treaty, if there is a absence, if there is no law, then state has an obligation. The third obligation जो हम देखते हैं वो important है. अगर किसी इंडिविजुअल के, what it says, to ensure that any person, whose rights or freedoms shall have an effective remedy. अगर आपके अधिकार का, मानव अधिकार का हनन हुआ है, तो आपको कुछ रेमेडी होनी चाहिए जहां पर आप जा सके और कह सकते shall have an effective remedy, notwithstanding that the by persons acting in official capacity. ये मतलब नहीं रखता है कि जो आदमी आपकी राइट्स की वायलेशन हुआ वो आदमी ऑफिशियल कैपेसिटी में काम कर रहा था और उसके कारण वो वायलेशन हुआ. The second part, so effective remedy की करते हैं. If your rights have been claim such a effective remedy, that has to be determined by competent judicial body. ऐसा नहीं है कि आप किसी से बोल दिए कि हाँ आपको रेमेडी मिल गया है. So decision has to be rendered by a competent judicial body or any other administrative body, but that has to be competent. आप ऐसे ही नहीं कह दिए कि हमने कर दिया है अब आपके अधिकार का सुन लेंगे और ऐसी बात है. A competent body must be hear the matter related a person whose rights have been violated. And third जो important obligation है वो related है कि once your right has been violated, person must, so decision rendered by the court, decision rendered by the competent body must be enforced. Enforced करने की बातें होती है और enforce उसका होना चाहिए is there. तो हम ये rights have been, how you are implementing that becomes the discussion, and that is the reason many states are not keen. What I have said in the beginning, if like once you no state likes that some external body or some external force interfere in your domestic affairs or discuss about all these things in there. अब हमारे हम जो कहते कि like we have a very good we have a very good judicial system. When we talk about the implementation, we look at our judicial system, how Indian judiciary looks into, how Indian judiciary implement the treaty, the international treaty. Court generally, court ने in series of cases, court had said, what court had said, in the absence of domestic law, occupying the field, any field, so court like an observation, in the absence of domestic law occupying the field or a specific field, the contents of, अगर आपके सामने में in the absence of domestic law occupying the field in any area, the contents of international convention, quote is saying, the contents of international convention and norms are significant. The contents of international convention and norms are significant for the interpretation of the guarantee of right to life, right to work, right to health, gender equality application पर। तो आप क्या देख रहे हैं, आप नोटिस कीजिए, कोर्ट कह रही है, हमारी सुप्रीम कोर्ट कह रही है, in the absence of domestic law in occupying area or occupying field, we can take help from the international convention and norms, international convention and norms. That international convention and norms become important for the purpose of interpretation, of the guarantee mentioned on the various articles of the constitution. So court itself, so like the interesting point which we have to notice here, the court is not saying about the first step which we have discussed. What first step we have discussed? So court is not talking about whether government of India signed, whether government of India passed enabling legislation or not. So court, Indian judiciary looks implementation of the human rights or respect of human rights independent of the executive measures. सरकार क्या कह रही है उनकी बातों को छोड़ो, उनको उनसे कोई ज्यादा ये नहीं है। सो कोर्ट कह रही है कि अगर हमें मदद की जरूरत होगी, in case if a particular area we don't have sufficient laws or something, we look into the help of the international convention and norms and interpret the constitutional provisions in there. And then it goes, any international convention not inconsistent, any international convention not inconsistent with the fundamental rights, any international convention. अब आप implementation की देखिए इन बातों में spirit and with the harmony with the spirit, its spirit must be read into these provisions to enlarge the meaning and content thereof. So court says if any international conventions not inconsistent, अब inconsistent है the constitutional objectives, if any treaty it's like any treaty which is consistent with the constitutional goals, constitutional values, that should be applied and enlarged. So that will help. So court emphasizes, judiciary is clearly stating, and court further says, this is implicit in Article 51C, Article 51C of the Constitution and enabling power. The court says Article 51C and enabling power of the Parliament to enact laws for implementing the international convention and norms. So वो कह रहा है कि Article 51(6), Article 253 and also entry 14 of the 7th schedule of the Constitution. So when हम international law की बात करते हैं, international treaty की बात करते हैं, तो 51C, 253, entry 14 of 7th schedule become important. So कह रहे हैं कि the court first so 2-3 points already we have said. The first point what court had said, in absence of, agar aap in absence of any occupying field, then we can seek help of international convention and international norms for the implementation and interpretation of the constitutional provisions. In absence, if there's nothing there in the constitution, area has not, then you can go. Second point, if treaty is not inconsistent with the constitutional values, if treaty is not inconsistent, so what is necessary? Treaty is consistent with the constitutional values. If any international treaty consistent with the or similar speaking same line what constitutional goal, we must take note of interpretation and application of the various provisions of the constitution. The third part, it says the constitution which talks about Article 51C, 253 and entry 14 of the 7th schedule list 1 also talks about the enforcement of human rights, enforcement of international treaty as such. Court further speaks about, court further strengthen and says the obligation of this court under Article 32 of the Constitution for the enforcement of fundamental rights. So court says that we have obligation, the court has an obligation under Article 32 of the Constitution for the enforcement of fundamental rights. So we have an obligation for the enforcement of fundamental rights, and then says in the absence of legislation, in the absence of legislation, and it says must be viewed along with the role of judiciary, along with the role of judiciary envisaged, role of judiciary envisaged in the Beijing statement of principle of the independence of the judiciary. So they have taken help of the soft law. They say that role of judiciary envisaged in the Beijing statement of principles of the independence of judiciary, which has taken place in 1995. And it says these principles, Beijing principles, regarding the role of judiciary. So it's a kind of an exercise where Chief Justice of India, Chief Justice of Bangladesh, Chief Justice of Pakistan, all gathered in a meeting organized by Lavasia in 1995 in Beijing. There they have made a commitment. So it's not a legally binding, but they have themselves taken, and this says minimum standards necessary for independence and effective functioning of the judiciary. And they say the objective of the judiciary is first to ensure that all persons. So what is the objective of judiciary? Objective of judiciary, they say, to ensure that all persons are, to ensure that all persons are, to ensure that all persons are able to live securely under the rule of law. So this is the role of judiciary, to ensure. So who will ensure? Judiciary. To ensure that all persons are able to live, all persons are able to live securely under the rule of law. No one is above the law, so rule of law. Second, court says to promote within the proper limits of the judicial function, to promote within the proper limits of the judicial function, to promote within the proper limits of the judicial function, comma, the observance, the observance, the observance and the attainment, the observance and the attainment of human rights. All these things we know, but this Beijing Declaration of 1995 outlines the first key, all persons. So court has to, it's not only the police or there, court has to also ensure that people should live securely under the rule of law. The second, it talks about within limit of judicial function, promotion of human rights, promotion and observance of human rights is also court has taken. The third point, which said to administer the law, to administer the law impartially, to administer the law impartially among persons, to administer the law impartially among persons and between persons, and between persons, among persons and between persons and the states. Court also cited one important case, that is the Nilabati Behra versus State of Odisha, 1993, 2 SCC 7466. Nilavati Behra versus State of Odisha, 1993, 2 SCC 746. And what is there in this case? A provision in the ICCPR. A provision in the ICCPR. A provision in the ICCPR. What ICCPR means? International Covenant on Civil and Political Rights. What provision they have referred? A provision in the ICCPR was referred to support. So a provision in the ICCPR was referred to support. Support the view taken that an enforceable right to compensation was referred to support the view taken that an enforceable right to compensation, that enforceable right to compensation is not alien. Enforceable right to compensation is not alien to the concept of enforcement of guaranteed right. Enforcement of a guaranteed right as a public law remedy. So when we talk about the if you injury or then you go to the private law document, like you go to the tortious liability, there you can claim. But it's like a public law remedy under Article 32, distinct from the private law remedy in torts. A public law remedy under Article 32, distinct from the private law remedy in torts. Court says there is no reason why these international conventions, and norms, why these international convention and norms cannot therefore be used for construing the fundamental rights expressly guaranteed in the Constitution of India, expressly guaranteed under the constitutional India. I take 1 minute here. In the Nilavati Mehra, what court has said ki they have their right to seek under the Constitution enforceable right to compensation. ठीक है ना? Enforceable right to seek compensation. Very important and interesting point which we have to learn from here. The provisions, what court has cited? Court has cited Article 9, paragraph 5. Article 9, paragraph 5 of the International Covenant on Civil and Political Rights. Article 9, paragraph 5 of the International Covenant on Civil and Political Rights. The court says, and you will be surprised that Article 9, paragraph 5, it says, Article 9, paragraph 5 of the International Covenant on Civil and Political Rights, it speaks about in case of illegal detention, victim has a right to seek compensation. Victim has a right to seek compensation, and compensation should be given. Victim has a right. What government of India has done on the day, that is 10th April 1979, that government of India has made a declaration that Article 9, paragraph 5 of the ICCPR is not applicable to us because there is no law, neither in the Constitution or any other laws, which allows a victim to seek compensation. So in 1979, government had said, not you and me, we don't have any provision under the Constitution also for granting compensation to the victims who were subject of some kind of brutality, some kind of a torture, some kind of harassment by the police to seek compensation. So government is saying, no, we don't have a law. 1979, we said we don't have any law. These officials are working on the states of, government of India. So they are working on behalf of sovereign. So they have a concept of sovereign immunity. They are not working on their own. They are discharging on behalf of the states. So while discharging their duty, a police officer may commit some mistake, but they are not subject of the any kind of persecution or any kind of victimization. What they are doing, they are simply discharging their duties on the behalf of the state. So the concept of sovereign immunity. If you remember the case, Kasturi Lal Rangia Lal, that long time back case in 1960-65, if I remember correctly, I think I'll cite also. In that case, the court had said the concept of sovereign immunity was upheld. But that is no longer valid. Today we have series of cases starting from the Rudulsa versus State of Bihar. Rudulsa versus State of Bihar, 1983, 3 SCR 508. Rudulsa versus State of Bihar. Bhim Singh versus State of Jammu and Kashmir. Rudulsa versus State of Bihar, AIR 1983, SC 1086. Rudulsa versus State of Bihar, AIR 1983, SC 1086. Bhim Singh versus State of Jammu and Kashmir, AIR 1986. Bhim Singh versus State of Jammu and Kashmir, AIR 1986, SC 494. People's Union for Democratic Rights, PUDR, People's Union for Democratic Rights versus State of Bihar, AIR 1987, SC 355. DK Basu versus State of West Bengal, AIR 1997, SC 610. So what court had said in these cases? Article 32 of the Constitution, Article 32 of the Constitution, the court has awarded compensation invoking Article 32 of the Constitution, and compensation were granted to the petitioners. In the all many cases are from the Bihar. Compensation to petitioners who had suffered, petitioners who had suffered personal injuries, who had suffered personal injuries at the hands of the officers of the government, who had suffered personal injuries at the hands of the officer of the government. The causing of injuries, the causing of injuries which amounted to, so causing of injury, so you go for the private law remedy, you go to the tortuous, but court has given constitutional tort. What we say constitutional tort, the causing of injuries which amounted to tortuous act, was compensated by this court under Article 32 under the public remedy, and I have outlined number of cases to you. In cases, here injuries, in cases relating to the custodial death, in cases relating to the custodial death or medical negligence, this court, the Supreme Court, cases relating to the custodial death and those relating to the medical negligence, the Supreme Court awarded compensation under public law domain, and I have mentioned Neelabeti Behra versus State of Odisha, which you have already read. State of MP versus Syam Sundar Trivedi. State of MP versus Syam Sundar Trivedi. State of MP versus Syam Sundar Trivedi in the 1995 4 SCC 262. People's Union for Civil Liberties versus Union of India. People's Union for Civil Liberties versus Union of India. AIR 1997 SC 21203. Paschim Bang Khet Mazdoor Samiti versus State of West Bengal. Paschim Bang Khet Mazdoor versus State of West Bengal. AIR 1996 SC 2426. SC 2426. Series of cases here. So the court had said, well, while public functionaries are involved and the matter relates, public functionaries are involved and matters relate to the violation of fundamental rights and matters relate to the fundamental rights or the enforcement of public duties the remedy would still be available under the public law, notwithstanding that a suit could be filed for damages under private law. So what court has said, while public functionaries, आपको हमेशा ध्यान रखना है, while public functionaries are involved in the matter relates to fundamental matter relates to the violation of fundamental rights, or the enforcement of public duties, the remedy would be still available under the public law, notwithstanding that a suit could be filed for damages under public law. The another important, you see how court has, so look in all the cases, court has gone beyond what government has stated. If I take you back to the 10th April 1979, government officially, which you can see, government says, though there is no law in India which allows right to seek compensation to the victims for the violation of the fundamental rights. So this is the developed by the court. And government of India, what government of India has done on 10th April 1979, ये आप जब research करेंगे और आप जब खुद देखेंगे तो आपको और interest होगा, आपको invoke होगा, आप लगेगा, you will be more motivated to know. So when you see that the document which has been given by the government of India, not by me, government of India has clearly stated, look, we don't have any right to seek compensation. We don't have a law in the constitution. So state saying there is no provision. And many cases, prosecutor also said, no, if injury is there, ask them to go to the private law domain. Why public law domain? There is no law. So state, in number of cases, now courts starting from the 1983 onwards, they said, no, nothing doing. There is in the public officials, if they violated, they have a responsibility. And then state, so there is a remedy there under the constitution, under the article 32, and we will pay the compensation. And we have identified series of cases where compensation has been granted. So you see the objective of the international treaty, which clearly states in case of under article 9 paragraph 5 of the International Covenant on Civil and Political Rights, it says in case of the violation, victim has a right to seek compensation. So international level that is there. Government said no, this law will not be applicable. Court has not bothered. Judgments have come much later, after 1979, after 1983 onwards, we see series of judgments are there. Court has not only granted, court has elaborated, court has expanded the definition for the right to seek compensation, and we must be proud that ultimately, if human rights has to be respected, human rights has to be implemented. Whether we are party of hundreds of treaties of the human rights, but the primacy of domestic judicial system remains paramount, remains paramount. So judicial system, local judicial system always like, we can join hundreds of the treaties. It doesn't matter. If you have no rule of law, if you don't believe in the independence of judiciary, if you don't believe on the people's participation, the things will not change. So implementation of the international human rights law, enforcement of the international human rights law depends effectively how we strengthen the national judicial system. It cannot be strengthened by merely becoming party to the series of international human rights instruments. And you say we are party, like China is party to series of human rights instruments. Turkey is party of the series of human rights instruments. Afghanistan is party of the human rights instrument, series of human rights instruments. They have signed. Can you say they are very good? They are respecting human rights? No. Your answer will be firm no. You don't need to go to the court. You can, China has signed only for image building. But when it comes to the domestic, there is no court. There is no independent court. Anybody, there is no rule of law. Anybody can be arrested. Any can be like, sedition series of law, like, secession law can be applied. Entire Hong Kong has been silenced in the China. So why the international human rights? So international human rights fails. International human rights fails miserably because there is no support system. There is no support system. So international human rights depends. Effective implementation of international human rights depends upon the strong pillar of judiciary, upon the strong pillar of the people's rights, respect of the people's rights by the state, upon the strong pillar of democracy, a strong pillar of rule of law, a strong pillar of independence of judiciary. If a state has a strong pillar of democracy, a strong belief in the rule of law, a strong belief in the independence of judiciary, non-interference, separation of power, or believing in the principle of constitutionalism, believing in the principle of constitutionalism, I feel that human rights is respected and protected only on those states. It doesn't matter how much treaty you have signed. It doesn't matter what is the need of international human rights law. So if national system is strengthened, that is there, that is the region. And this has gone to the international community. International community has also realized treaty, like, human rights treaties, we have number of treaties. But when we come for the implementation, we find treaties are not implemented properly. The focus shifted from there in 1991. In 1991, that is the Paris principles were adopted, which was subsequently endorsed by the General Assembly. What is the Paris principle? Paris principle says strengthening of national system for the promotion of human rights. Strengthening of national system. So they have globally, people have realized strengthening of national system for the promotion and protection of human rights. And they said we must create national human rights institutions. National human rights institutions for promotion and protection of human rights. So Paris principle emphasized on the independent national human rights institution, and that has led to establishment of the National Human Rights Commission of India in 1993. India is among the few countries in the world which has established National Human Rights Commission. So you understand what is important for the implementation of the human rights law. Implementation of the human rights law is the national judicial system. An international treaty also recognizes the primacy of the judicial system at the international level. They also talk about the international level is there. All right. Few points which we talk about the court in one of the case, very important case, if you have a chance, you can look into the chairman railway board and others, where court has, so I mentioned, in fact, I mentioned to you Bisakha case, the first case which I have used, where inconsistent, the 3 points I have highlighted. So I just use that one, how court has looked into the implementation. So I mentioned you the Bisakha case, and then another case like in which I'm using, where interpretation and application of the international human rights law by the court, and that is the another case which was decided by the uh, Sagir Ahmad, Justice Sagir Ahmad and RP Sethi, Justice Sagir Ahmad and RP Sethi in the 2000. So old case. But international human rights and convergence of international human rights and domestic human rights law is become very important. In this case, there like foreign national was involved, like a foreign national, that Hanufa Khatun, she was raped in the Calcutta, Bangladeshi national. She was raped by the employees of the Calcutta railway board, and that is the railway board has become the case. So in court had said, it was contended that fundamental rights in part 3 of the constitution are available to both citizen as well as the non-citizen. Citizen and non-citizen. And then court said, but the prosecutor, they're arguing, they're saying, foreign nationals have fundamental rights are not available for the foreign national. However, court says, foreign national, which we know that wherever the term persons are used, that is applies to the citizen and non-citizen. Wherever the term, Article 19 is not applicable because it talks about the citizens. 15 is not applicable, it talks about the citizen. 16 is not applicable, it talks about the citizen. But Article 14 is applicable, 20 is applicable, 25 is applicable, 21 is applicable, wherever term persons are used. So persons include citizens as well as the non-citizen is there. And then court also says ki this argument by the prosecutor fails on two grounds. First, because domestic jurisprudence, like what court is saying, domestic jurisprudence based on constitutional provisions. First, domestic jurisprudence based on the constitution. So we have already domestic jurisprudence which clearly states that even the foreign nationals have certain fundamental rights, not all fundamental rights is there. And secondly, that is the important, on the ground of human rights jurisprudence. So one is the jurisprudence, domestic jurisprudence, and second court says on the ground of human rights jurisprudence based on the Universal Declaration of Human Rights. So it could say it's again based on the ground of human rights jurisprudence based on the Universal Declaration of Human Rights. UDHR is talking about 1948. And then court says, so human rights jurisprudence based on the Universal Declaration of Human Rights, which has the international recognition, as the moral code of conduct. Moral code of conduct. So what is saying, which has the recognition as the moral code of conduct. And then court court has extensively cited the rights, the preamble of the Universal Declaration of Human Rights, Article 1, Article 2, Article 3, Article 5, 7, 9 in the judgment. And then court also says the international covenants and declaration as adopted by them have to be respected. What the point I have been saying, the court in this case also says the international covenants and declarations as adopted by the United Nations have to be respected by all signatory states. And the meaning given to the above words in those declarations and meaning given in the above words in those declarations and covenants have to be such as would help in effective implementation of those rights. So court is saying, state has an obligation. Once you become a party, you have to give respect. And then court says, the applicability of the Universal Declaration of Human Rights and principles thereof. It says the applicability of the Universal Declaration of Human Rights and the principles thereof may have to be read, may have to be read if need be, agar situation demand karta hai, if need be, into the domestic jurisprudence. So court, like दो cases की बातें की आपको, उसमें क्या court is like open. Court is not implementation. So implementation of human rights in India, it's much wider, much much comprehensive. When it comes, it's not based on the procedural aspect. It's not depending upon the procedural की क्या है, article 51C, 253, entry 40, ये सारी बातों को नजरअंदाज करती है हमारी कोर्ट्स। और जो सही है, जब हम एक आम आदमी बात करते हैं, जब हम किसी बात पर आवाज उठाते हैं, तो हम कभी हमारा अधिकार है, हम इन बातों पर कभी नहीं जाते कि हम उस पे हम साइन किए हैं, उसको हम रेटिफाई किए हैं, उसको ये किए हैं, सारा चीज। सो कोर्ट बड़े ऑब्जेक्टिव तरीके से, इंडियन जुडिशियरी इन अ वेरी settled manner takes note of the international treaty and applies it in the domestic level, and that is very interesting is there. The court also highlighted it here, like in year 1988, a judicial colloquia has taken place in Bangalore. We all have a duty. It's not like you have to learn, you have to, you are the agent of change. You have a duty to promote, you have a duty to protect the human rights. You have to play very important role the way court plays, and we can on our own in classroom teaching, making students sensitive to go back and to say that these are your rights. People have no idea what rights they have. Assist them, particularly a large number of weaker sections of the society, vulnerable sections of the society. So we can also play a very important role, and that is the reason I have modified and I have said judges, lawyers, and academicians. So I added here a declaration which was adopted in 1994. Judges, lawyers, and academicians have duty to familiarize themselves with the growing international jurisprudence of human rights, and particularly with the expanding material on the protection and promotion of human rights of women. हमें इन बातों को ध्यान में रखते हुए आगे बढ़ना है और अपने आप को समझना है कि ये सारी बातें किस तरीके से ह्यूमन राइट्स की प्रमोट की जाए। और इसी के संदर्भ में जो आज सारी बातें हुई, सारी चर्चा हुआ, इसका मेन उद्देश्य यही है कि ये सिर्फ एक क्लास नहीं है। अगर आप ये सोचते हैं कि मैं क्लास करके और ये कर लेते हैं, you have to take that responsibility, you have to learn whatever in 1 hour I can say I did, but I think you have a long way to go. You have to look into the entire aspects or gamuts of the uh, human rights and spread the understanding of the human rights to the people or the students who you teach or whom you interact day to day. That will be the major objective of the human rights implementation of human rights will be ensured. With this I thank you, and thanks all of you for your time, your patience, for hearing me for 1 hour. And now I request Dr. Barma ji
Sir,
take the floor.
sir, have you any question,
Yes, sir.
participants?
Yeah.
Yes, sir. Pranam, sir. Sir, it's
Pranam.
me, Dr. Nutan Kumari, Department of Political Science. I'm an assistant professor in PPS College. Sir. Oh God. Yes, sir.
हाँ बताइए.
There was some problem. Yes, sir. Sir, you had talking about monist polity and dualist polity. Sir, kindly let me know that how when you said that if a monist society or monist polity is a party to international treaty, it automatically it becomes applicable in that very polity. Sir, kindly elaborate some more points with examples.
Yeah, I talked about the international law application of so international law, states are divided in monism. They believe in monism and dualism.
Yes, sir.
So monist states very few states they believe the origin of international law or domestic law are same. They are they cannot be segregated. They cannot be separated. So if a state any treaty has come automatically, if we are party it applies. We don't need to do anything. So they see origin of the international law and domestic law in the same thread. So that is not so. Monists are believer, like in respect. Dualists also believe the international law, but they believe that it requires extra step to be taken in the implementation, and that is the reason. They have sometimes they discuss the treaty in their parliament, in the Senate, like in the United States, before accepting the legal obligation. So some states like United States, if their parliament they become party, they accept the legal obligation when that treaty has been ratified by their Congress and Senate. What we are doing, we accept the legal obligation, then come back to the parliament, but not in all cases. So what we are doing, we are following dualist, but in true sense, our human rights treaties have not been converted as a law of the land because we have not completed the third task. The third task, passing of enabling legislation as mentioned in the Article 253 of the Constitution. Many states, the second and third, a decision to become a party of the international treaty has been approved by parliament or their respective form of a government. So they don't need to do. Once they accept, automatically that implementation. That is the dualist is there, and here in the same is the monism and dualism.
So excuse me, sir. So example of monist country.
Example of money, I'm not. I think Sweden and some of the countries are there. Not like large number of
So
countries.
it's a neutral country.
Lot of countries, but I'm not quite sure. But I think some of the small countries are the monism countries there.
Yes, sir. Monarchical countries maybe.
Even England believes in dualism. USA, India, Iran, Iraq, Pakistan, they all are like dualist because they don't want to. The major problem is no state wants. Out of 193 states member of the General Assembly, they don't want matters related human rights to be discussed. The moment you become monism, you are subject of more criticism. So they avoid. So states are like, they keep that human rights is a subject which falls essentially within the domestic jurisdiction of the state. Only state has a say, no other person. So that is the reason we have large number of dualism, but less
Thanks
monism.
a lot, sir. Thanks.
Thank you, Ritan. Thank you. आवाज नहीं आ रही पांडे जी
सर नमस्कार, मैं आर्ट्स कॉलेज से हूं सर। कल्चर मेरा स्पेशलाइजेशन है। बहुत ही अलग फीलिंग है इन तमाम अधिकारों के बारे में जान के। अब तो ऐसा लगने लगा है क्लासेस करते करते कि चलिए एडवोकेट तो नहीं, कम से कम सलाह देने लायक हो गए हैं और खुद एक तरीके की आपकी अपनी चेतना भी विकसित हो रही है टूवर्ड्स रूल्स, लॉ, सारी चीज़ें हैं। तो मैं बहुत आभारी हूँ आप सभी का। थैंक यू सर।
थैंक यू पांडे जी, थैंक यू।
नमस्कार सर।
नमस्कार नमस्कार।
मैं चंद्रभूषण श्रीवास्तव, कॉलेज
कहाँ
ऑफ
से
आर्ट्स एंड क्राफ्ट्स पटना से, और इस रिफ्रेशर कोर्स को ज्वाइन करने के बाद ह्यूमन राइट्स के अंतर्गत क्या क्या कानून है और ये सारी चीज़ों की जानकारी हुई, जो कि हम अपने विषय में भी इस चीज़ों को देखते हैं और आगे भी इसको कॉन्शियस होकर के हम अपने विषय के अंतर्गत डालने की कोशिश करेंगे, जिसमें बहुत से कलाकार जो कार्य करते हैं लेकिन उनको नहीं पता कि ये ह्यूमन राइट्स के अंतर्गत ही कार्य हो रहा है, कि संवेदना जो काम कर रही है। स्पेनिश गृह युद्ध के बाद जो है पिकासो ने भी बहुत वर्निका करके एक पेंटिंग बनाई थी। तो इस तरह से बहुत से आर्टिस्ट जो काम किए हैं और उसमें ह्यूमन राइट्स का पूरा ध्यान है उसमें। तो हम लोग भी आगे इस तरह के कार्य करने को, तो इससे क्लास करने से और ज़्यादा मेरा ह्यूमन राइट्स को लेकर के
थैंक यू श्रीवास्तव जी,
ज्ञान बढ़ा है। धन्यवाद सर।
मिस रुचि, रुचि।
Good morning, sir.
गुड मॉर्निंग।
Good. Yes, sir. Sir, I'm Ruchi Singh. I'm an assistant professor here only in Patna Law College, Patna University, Patna. And I have heard, sir, at many platforms. It was indeed very enriching to listen to you again, sir. Thank you so much.
Bandana, Dr. Bandana.
Yes, sir.
Dr. Bandana, please
Yes,
introduce
sir.
yourself.
नमस्कार सर,
नमस्कार मैम।
मैं BRM कॉलेज मुंगेर यूनिवर्सिटी से हूँ सर। मेरा सब्जेक्ट फिलॉसफी है सर।
अपना वीडियो ऑन करिए।
यस सर।
फिलॉसफी से आप समझने की कोशिश कीजिए, ह्यूमन राइट्स की बहुत ज्यादा अच्छाई फिलॉसफी में हम
हाँ
कमजोर
सर,
हैं।
मैं अपना प्रोजेक्ट भी उसी के अनुसार तैयार कर रही हूँ।
फिलोसफिकल अंडरपिनिंग को देखना चाहिए ह्यूमन राइट्स में हमारे, और हमारे रिलीजियस पर्सपेक्टिव से भी देखा जा सकता है। वो सब कुछ एंगल में कुछ काम किए हैं, लेकिन बहुत कम हुआ है।
हाँ सर, एक क्लास भी हुआ है सर फिलॉसफी में, RC सिन्हा सर लिए हैं, वो बहुत मार्गदर्शन का काम कर रहा है सर।
वेरी गुड, वेरी गुड। चलिए,
डॉक्टर रमाशंकर,
रुचि कुछ बोलना
डॉक्टर।
यस रमा जी।
Good morning, sir. My name is Dr. Ramashankar. I am from CM Law College, Darbhanga, sir. It was very impressive to hear you, sir. Your lecture was really very highly intellectual, and I would like to hear you again and again, sir.
थैंक यू वेरी मच रमाशंकर जी।
सर, आज तक केवल आपका नाम सुना था, आज पहली बार सर देखें और सुने आपको।
जोगेंद्र जी को धन्यवाद देते हैं, जोगेंद्र जी ने बुलाया और हमारे छात्र अभी गुरु भी है सामने में, तो गुरु को भी दिया जो बहुत होगा।
जी सर, वेरी थैंक यू सर। पहले बहुत बार सुन चुके हैं सर, ILI के मनोज सर हैं, ILI के मनोज सर है, आज सर पहली बार आपको सुनने का मौका मिला सर।
थैंक यू वेरी मच
सर। इट वाज रियली वेरी इम्प्रेसिव।
और रुचि साथ में है, ऑन हो गया।
गुरु प्रकाश जी,
गुरु को बोलने दीजिए थोड़ा। गुरु आ जाओ एक यस।
गुरु जी ऑन करिए अपना 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 ऑन करिए।
सर नमस्कार।
नमस्कार गुरु, सब ठीक हो ना, अच्छे से है ना?
सब आशीर्वाद सर। आपका भाषण सुना सर मैंने थोड़ा बहुत, और बहुत सर प्रभावित हुआ। मैं लगातार आपसे इंस्पिरेशन लेता रहता हूँ, और थैंक्स टू योगेंद्र वर्मा सर दैट ही वाज एबल टू ऑर्गेनाइज सच अ सक्सेसफुल कोर्स फॉर द बेनिफिट ऑफ ऑल द फैकल्टी फ्रॉम अक्रॉस द स्टेट। ये सर पूरे मतलब बिहार के अलग अलग पार्ट से, बेगूसराय से और झारखंड से बहुत सारे सर असिस्टेंट प्रोफेसर आए हैं। ये सर के नेतृत्व में ही संभव हो पाया सर। और आपको सुना सर, आपके लिए सर बहुत बहुत प्रणाम और आभार सर। दिल्ली आके आपसे आशीर्वाद लेंगे सर।
हाँ बिल्कुल बिल्कुल सर, बहुत बहुत आशीर्वाद है। थैंक यू वेरी मच।
थैंक यू गुरु जी, थैंक यू। तो अब सर से इजाजत हम लेते हैं। सर थैंक यू वेरी मच सर।
थैंक यू।
And whenever we need your blessings, sir, we got always your blessings, and I expect in future, sir, we get your blessings, and this is the very fortunate, and the Department of Law always be getting your supports and help, sir. Thank you very much, sir.
थैंक यू आप सबको बहुत बहुत धन्यवाद। थैंक यू वेरी मच एंड ऑल द बेस्ट।
थैंक यू सर। थैंक यू सर।
थैंक यू सर। प्रणाम। थैंक्स सर।
प्रणाम सर।